So I'm going to start off with a little bit about me, just so you can put a little bit of a face to the name. Hopefully we never cross paths in a professional capacity, but just in case, a little bit of an introduction of myself. So I've been practicing for 15 years. I articled and practiced with a big firm in Winnipeg for the first 5 of that, doing mainly admin litigation, labor and employment primarily, but some other things as well, like transportation work, tribunal work. And at the firm, we also had a big corporate commercial presence. So I did a bunch of that while I was articling. So got a good broad base while I was doing that. 10 years ago, moved over to the Law Society of Manitoba, started investigating complaints for them. And like Jessica mentioned, last year I became director of that department. So still do some investigations, but do a lot more oversight now. About a year ago, started working here, doing the investigations for the Law Society of the Northwest Territories, which has been fantastic. Being able to continue the work that I'm doing in Manitoba, but also in a different jurisdiction has been very interesting and a lot of fun. Outside of work, I've got a couple of daughters who are into rhythmic gymnastics and volleyball. So I spend a lot of time in gyms, various gyms. To get myself outside, I ref football games and I run the Manitoba Football Officials Association, which is the organization that provides officials for high school football all across the province. So what we'll cover today. A couple of things we're going to do. We'll talk about the main types of complaint that we get. The Law Society of the Northwest Territories website covers in pretty good detail in their complaints section the different types of things that could come up. And you know, there's not a whole lot of difference between the types of complaints that come up in this jurisdiction versus the type of complaints that come up in Manitoba or, you know, Alberta, other places. The things that are going to make a client upset in Yellowknife or Inuvik or wherever are the same things that are going to make a client upset in Winnipeg, Brandon. It's going to make them come to the Law Society, and we'll have to deal with it at that point. How you can avoid a complaint, not always possible, but we'll get some tips both to proactively deal with things to begin with, and then deal with an issue when it arises from the client before it comes to the Law Society. One of the things we do is we recommend that clients take up the issue with their lawyer if possible and try and resolve it between the two of them. So if you get that opportunity, hopefully you're able to take advantage of that and it never ends up in the Law Society's hands. And the best way to handle a complaint that you can't avoid. So it can be stressful to deal with the complaints process, right? The Law Society writes to you, asking for your response. What do you do at that point? So let's dig into those. Main types of complaint. What does everybody think the main types of complaint would be? Any thoughts?
Slow response, no response.
Overcharging.
Fees?
Fees.
Yeah, I mean, generally we don't deal with fee complaints, but quality of service, and we'll touch on the fees a little later as within that context, yeah. Anything else?
Competence.
Competence?
The lawyer didn't know what he was doing.
Yeah, to a certain extent. I mean, generally, lawyers do know what they're doing. More so than the clients would be, yeah. Yeah. But again, that would wrap up in the quality of service stuff, right? And that, you know, they want you to take certain steps and you're not doing it. And again, we can touch on that a little later with instructions from the client. Anything else?
Trust accounts.
Trust accounts? We don't see that a lot. Lawyers are generally very good with dealing with trust accounts. In the sense that it doesn't rise to the level of complaints. So like audits, for example, there'd be a lot of ticky-tack stuff that they'll give you reminders on and recommendations to improve your practices, but a lot of that doesn't rise to the level of professional misconduct. So some of the other things we look at would be conflicts of interest. Courtesy, believe it or not, comes up relatively often, and withdrawal. So obligations on withdrawal. So digging into those. Quality of service is by far the biggest area of concern that we see. And it's a huge area. It encompasses a lot of things. So this is the rule from the code. You have a duty to provide courteous, thorough, and prompt service to your clients. And it's service that is competent, timely, conscientious, diligent, efficient, and civil. What does that mean exactly? Commentary 5 under that rule sets out a whole list of things, expected practices that lawyers should follow. So if you haven't looked at that recently, maybe have a look at it. It is a good thing to review from time to time. Here's some of them. They would include keeping the client informed, responding to their communications and requests for information, getting instructions from them, pursuing their matter in a timely way, and reporting out to them when the matter is finished. So you'll notice only 2 of those actually have to do with the work itself. What are the other 3?
Communication.
Communication, 100%. Communication is the biggest thing. And we'll find that almost all of the complaints we get at some point, it's triggered by a breakdown in communication between the lawyer and the client. So nothing makes a client more upset than not hearing back from their lawyer, not getting updates. This is more often than not the biggest thing going on in their life at the time. You know, not necessarily for the lawyer, but for the client, they want to know that their lawyer's on top of things. They don't want to be left in the dark. They don't want to be surprised by anything. And when that breaks down, we do see a lot of complaints. And I'll jump into tips a little bit here. One of the things to help you avoid that is managing expectations for the client right off the hop. If you've got a client who likes to communicate a lot and is, you know, trying to get in touch with you 15 times a day, manage that, right? Like that's not good for either you or them. It's going to run up their bill and it's going to take you away from actually being able to do their work and do the other work that you need to get done. One good tip for that is sometimes just set it right out in the retainer off the hop. That, you know, you'll get back to them. If they email you 15 times a day, get back to them once, right? Deal with everything in one communication and leave it at that. You don't necessarily want to get sucked into the communication style that they want. And being able to communicate that right off the hop or when it comes up with a client is going to go a long way toward managing that relationship as you go along in the file. But it's also not about returning their calls all the time. Sometimes clients have questions that they need answered, right? Not knowing the answer to that question, it's not something you can ignore. We do see that quite a bit. Client asks a question that, you know, lawyer thinks is stupid or lawyer doesn't know how to answer, so they just ignore it, keep moving along, hope it goes away. Not a great strategy to deal with things. If you don't know the answer, just tell them right off the hop that you'll look into it, get back to them, and then actually do that. If it's a question that you've already answered 5 times, just say, you know, refer to my email of whatever date. If you have any further questions after that, feel free to reach out. On the other end of the spectrum would be clients who aren't getting in touch with you too much. You have an obligation to communicate with them as well, keep them updated, especially if things are going on their matter. We've seen this on criminal cases, for example, where you don't need instructions from the client. They say they're not guilty, it's going to trial, but there's still case management going on. Keep them updated as to what's happening. Because, you know, when they haven't heard from you 8 months down the road, they're going to come to us and say, what's going on? How come my lawyer's not getting in touch with me? So as for the work itself, delays in getting work done would be one of the biggest things we see. A lot of clients don't have a good understanding of how long the legal processes actually take. They think it's just a matter of walking down to the courthouse and getting in front of a judge and then away you go. Obviously, that's not the way it works. So being able to communicate right off the top with the client as to the steps and anticipated timelines is a helpful thing. And then as the matter develops, when there's changes in that, being able to communicate with them that, you know, this has happened, it's going to affect the timeline in this way. So one matter we did see, and getting the work done in a timely way. You know, sometimes it is on the client and that they have certain expectations. Sometimes it's on the lawyer and that they have a million other things going on and they can't necessarily get to this, right? So we had a matter not that long ago where a lawyer went through all the processes. It was a family matter. They got the order they needed for the client, but then didn't complete the order and file it with the court and get it endorsed. So it wasn't necessarily enforceable by the client. They couldn't take a piece of paper to the police and say, you know, these are the other parties' obligations, they're not complying with them. And that sat outstanding with the lawyer for 3 years. So the client would follow up from time to time and say, where's my order? The lawyer would just ignore it because it was at the bottom of the pile. They had a million other things to do. They didn't want to get to it. 3 years goes by very, very, very fast when you're a busy person. And then the complaint comes to the Law Society and they look back at it and say, oh geez, 3 years have gone by. They filed the order, but by then it's too late. They still got charged for failing their service obligations to this client. So how quickly do you actually need to deal with matters? Any thoughts on that? We get this call all the time from clients saying that, you know, this is my matter. What is the Law Society's standard on how fast this has to be done?
It was reasonable.
Yeah, basically, it's a reasonableness standard. Absolutely, it depends. So some work has to be done faster than others. Some work is urgent, obviously, and you need to actually spend the time to deal with it on an urgent basis. Other work, not so much, and it takes whatever reasonable amount of time it takes. Clients are going to think that everything's urgent. Not necessarily the case. Last thing is instructions. So under the code, you have an obligation to get your instructions in writing or confirm them in writing. Generally speaking, that would be major instructions on a file, major steps you're taking. Either get those instructions in writing, you know, typically by email or something like that. Or if you've had a conversation with the client and they tell you that this is the way they want to go with the file, follow up afterward by email, by letter saying, this is what we talked about, this is the direction we're going. If you don't do that, it's very easy for the client to come back after the fact when things haven't worked out the way they wanted them to say, you know, I didn't want the lawyer to do this, but they did it anyway. It helps a lot if you've got that letter confirming that these were the instructions, everybody was on the same page and it didn't work out, but that's the way it goes sometimes. Who do you take your instructions from? It may seem like a simple question, but husband and wife come to you and property is only in the wife's name. Husband is giving the instructions to you. What do you do there? Do you run with those instructions? No, it's the wife's property, right? So you've got to get the instructions from her. The husband can, you know, say what he says, but ultimately it's her call as to what steps to take, right? So we have seen this fairly regularly, believe it or not, where couples will come and it's only one person within that couple's rights who are being affected, but it's the other person who's giving the instructions. And then again, when things don't work out 8-12 months down the road, the person who's affected is coming back to the Law Society saying the lawyer's doing all this, they never even spoke to me about it. And really the lawyer has no defense to that, right? They're acting on the client's behalf without any instructions at all from them. Do you always have to follow your client's instructions? No. So you have obligations to the court as well, right? So if your client's instructing you to commence a motion that you think is frivolous or vexatious, you don't have the obligation to follow through and do that. You actually have a greater obligation to the court and the administration of justice not to go down that road. How do you handle with a situation like that, though? What do you have to do in relation to your client when that comes up? Yeah, tell them that in your professional opinion, it's frivolous or vexatious, and they've got the right to go somewhere else and find another lawyer who may not have the same opinion and is actually going to do the work. They have the right to handle their own matter if they want to do that, and go down the road they want to go down. But again, it's that communication piece, right? Explaining it to them, giving them their options, and then they go however they go. Conflicts of interest. So a lawyer has an obligation not to act or continue to act for a client where there's a conflict of interest except as permitted under the code. So that's pretty simple, right? Conflicts are nice and easy. Not so much. Conflicts are, I think, the most complicated type of file we get. Sometimes they're obvious, and sometimes it's just a matter of the lawyer didn't do what they needed to do, and had they turned their mind to the conflict issue, they wouldn't have acted in the first place. Other times, you know, it can get very, very complicated. They are something you need to consider throughout the life of the file. What may not be a conflict situation now can turn into a conflict situation. So we had a file not that long ago where a firm was acting for a group of corporations held by one family. And everything was fine, like the family got along, everything was good. But one of the corporations held the land that housed the business of another corporation. The land holding company was held by certain family members. The operating business corporation was held by other family members. Conflict did arise. It would have been very easy for the firm to try and whistle past that, but you can't, right? Conflict arises. The clients need to get independent legal advice and deal with it, you know, their own separate way. You're always going to be there. You know those businesses inside and out. Once that dispute's resolved, they can come back to you. But you can't act for both sides when there's a dispute, right? Another thing that's come up is conflict searches. So a lot of lawyers very good at conflict searches, especially when the client's coming in off the street. Where trouble seems to arise is where you're doing somebody a favor. It's more or less an informal thing. Friend comes to you and says, you know, I've got this dispute with a company. Can you write this demand letter because it'll look better coming from a lawyer than it will coming from me? And if you don't think about it, you just write off the letter, send it off to the company. Company's going to run back right to the law society immediately and say, you know, our lawyer is this other lawyer down the hall from this one. Their partner that they practice with, this is our law firm now trying to intimidate us. What's going on? And again, you really have no excuse for that, right? It's something, you know, you dealt with it informally, but it's something you should have done a conflict search on and told the person, you know, you just can't do it. It's a basic thing, but it looks terrible when it blows up in your face. So make sure you're always doing those conflict searches. Any questions on conflicts or quality of service concerns before we move on? No? Yeah. Courtesy. So this is something that's coming up more and more as time goes on. I think the world's becoming an angrier place, for better or worse. It's becoming a lot easier for people to lose their cool, and we have seen a little more frequently lawyers losing their cool on their clients, opposing parties, court staff, things like that. But when that happens, people are offended, and the first thing they do is run to the law society. So when you're in that kind of situation, make sure you recognize that and you're able to step away, right? Go yell in your car, type out an angry email on a Word document and then delete it later on. Do things like that so you're not actually acting discourteous toward your clients or opposing parties or, other third parties that are involved in your practice. Because that will come back to the law society pretty quickly. Questions on that?
It's a quiet bunch today.
Yeah.
How do you evaluate that, like, that discourtesy? Does that look like on your end?
On our end, so we see a whole broad range of things. Like some people think a demand letter is discourteous because you're, trying to threaten them. Obviously not. That's just like the normal course of things. If it involves profanity, if it involves like significant personal attacks, then that would be the other end of things. Then you're probably going to get, some kind of finding against you that maybe you didn't act in the most professional way. Ultimately, it's your obligation to be professional, right? That's something we have to evaluate on the circumstances. There's no black and white, but general guidelines. I think everybody has a good sense of what would be professional and what wouldn't. Anything else on that? Okay, withdrawal. So withdrawal is a situation where people tend to get pretty upset, especially if they don't see it coming. They feel like they're being abandoned by their lawyer. And when they're being abandoned by their lawyer, the first call is to us more often than not, as opposed to trying to find a different lawyer. So your obligation under, all of these obligations are under 3.7 of the code. -1 is just the general one. You can't withdraw from representation except for good cause and unreasonable notice. So good cause, there's a couple of different things and they're set out elsewhere in the code. Things like loss of confidence. If you're giving advice to the client and they're not following it, that could be cause to withdraw. Fees in some circumstances, if you've given them a ton of notice about paying their fees and they're just not making arrangements to pay, you don't have to continue working for free. You can withdraw at that point. Competence as well is something we see from time to time. Like if you're a real estate lawyer, for example, and you do a real estate deal for somebody and things start to go sideways, it's looking like it's at the point of litigation. You tell the client, you can't move forward with this. You don't do litigation. Here's the name of 3 lawyers who might be able to do it for you. Some people interpret that as, you're abandoning them at the most difficult points of this process. They'll come to the law society. You have an obligation not to do work you're not competent to do. So if you're not a litigator and you don't feel competent doing litigation work, that's fine. Feel free to tell the client they have to find somebody else. Make sure you put it in writing that they need to find somebody else. And it's helpful if you put that stuff in your retainer at the beginning as well. So they know that this is the scope of the services I'm going to provide. If it gets to another point, if you need litigation on your estate, if you need litigation following the real estate transaction, I'm going to give you the names of other people that you can go to, but I'm not going to do that myself. On discharge or withdrawal, you have the obligation under the code to notify the client in writing that you have withdrawn, the reasons for withdrawal, and in the case of a litigation, that they should expect the court process to continue and they should get a lawyer right away. We do from time to time see situations where lawyer and clients have had a blow up argument and the lawyer says, all right, that's it, I'm done. That's all. They don't put it in writing. The client is of the opinion that yes, we had this blow up argument, but we can work past that. My lawyer's going to continue acting for me. And when you have that miscommunication, it gives rise to a lot of issues because they're assuming that their matter is ongoing. You're assuming that you're not working on it anymore. It's sitting stagnant. That's a problem. So it is important to follow up when you are withdrawing, to put it in writing. as well as the reasons, and to encourage them to get another lawyer and move on as quickly as they can. Any questions? I'll withdraw.
What would be your suggestion? So I'm going back to legal aid. Often we have to get off a file because we just don't hear from our client, even though we've written, called, whatever, but there's already a hearing date. If we filed a notice of motion, would you, or notice of withdrawal, would you recommend that we still go and appear and let the court know that we've withdrawn? Like, they're gonna see it.
So I'm not familiar with the court rules in the Northwest Territories. In Manitoba, you have to file a motion to withdraw. So if that's the case, you've notified your client well in advance that, you know, you gotta get in touch with me. Otherwise, I will be withdrawing. And then once you hit that point where, you know, you've given them a deadline, they haven't met it, then you file your motion to withdraw. And
So I'm just asking, because sometimes the court will ask you if you're already there on another matter to speak to it, and it's like, I filed the withdrawal. And I think at that point, you're crossing over to potentially still representing them or being back on the record. So from a complaints perspective, it would be better just to say, I'm not talking to them, like. But then you're in that awkward position with the court.
yeah, I mean, it's circumstantial, right? I don't think it's gonna be professional misconduct if you do speak to it.
Good.
The biggest tip there would be to paper your file, right, and actually have all those letters on the file saying that I've reached out to you, you're not getting back to me. And then if it does end up in our lap and we have to investigate, then you've got all that information you can provide to us. And that should be the end of it from there. Any other questions about complaints generally before we move on?
So to what extent, when you're investigating a complaint, do you consider like the context or the climate of the place? So obviously we have the code, we have to follow it, but there is, you know, practices that occur outside that are like generally accepted, kind of like what my colleague here was saying. So I guess to what extent do you consider those type of things when you consider or when you conduct an investigation?
They're absolutely considered, and when you respond to a complaint, you should include as much background as you can. Things like that, like circumstances and general practices. At the end of the day, your obligations under the code are your obligations under the code. So if there's a general practice to ignore the obligation under the code, you still gotta do it. But yeah, it is something absolutely that we would take into account.
Just because up here, I feel like there is a lot of gray areas, especially with respect to confidentiality. If you are a criminal lawyer, for example, and you aren't able to track down your client, you may have the court worker go and track down your client, which at that point, you've already kind of, you know, broken that approval.
And
So I guess I just wonder, because there is like differences here that may not be so pronounced down south and larger city centers.
yeah, again, it's something we would take into account for sure. I don't know that anyone would complain that you asked a court worker to check up on them if they haven't been in touch with you, but I mean, in the event that
They're
happens.
related, so they do complain. I'm not a lawyer, but there are people like, you know, who are related, who are like, why don't you tell my aunt to come find me? It's like, that's never happened to me. Because I don't- But things like that.
Yeah, again, like I said, the circumstances, put them out in your response to the complaint for sure. And it is something we take into account.
Just a little bit curious of the things, like now that you've taken over doing the complaints. I had to go through the complaint process before that happened, and I found that the screening wasn't really there, in my opinion necessarily, and it was a very unique situation, and I think a lot of complaints just went forward because of that situation. But what are the criteria that you use now that you've taken over to like screen complaints, whether or not they even
So
go through?
screening happens,
The chair.
yeah,
Oh, okay,
screening happens before it gets to me.
okay. So it's still the same,
Same,
okay,
same. So still, it would be the chair or one of the vice chairs.
okay. Good to know.
But generally speaking, the rule would be, you know, if there's concerns on the face of what's provided, then it would go to investigation. If there's no concerns at all on the face of it, it would just be summarily dismissed. So a lot of times, like people can be sneaky with the way they word their complaints.
Oh, it was, I know exactly, it's not,
Yeah.
well, someday somebody will tell you the story of what happened.
I mean. You may have already, but with
Yeah.
names, obviously,
Yeah.
so I'm just gonna pipe up and say. That Chris is here along with our chair for the discipline is hiding faculty, and we are in the process of reviewing the new act that received dissent and giving comments for the new rules. We currently under our new act and rules, we don't have a mechanism to appeal a complaint outside of a judicial review. And sometimes that can be a deciding factor, whether or not to move a complaint through an investigation. If we are certain that it's going to be reviewed. The new act does allow for an appeal process.
Oh, okay, sorry, I thought you meant.
Sorry, no, and the new act will
Oh.
allow for somebody to appeal to the executive for a review, which is great. Because now, I mean, is it a fear-based approach sometimes? If we're certain that somebody is going to, JR a decision to dismiss prior to investigation, we're gonna investigate it.
Does that answer the question?
Yeah.
Yeah, perfect. Okay, anything else on that? Before we move on? Okay, tips to avoid complaints. So the biggest one, like we talked about, is communication, right? Almost, or I shouldn't say almost all, but a very vast majority of the stuff we see stems from a communication breakdown somewhere along the line. Make sure that that communication with your client is there. It can be a difficult skill. I get that. Some people are a lot better at communicating with their clients than others are. If it's something you're not great at, work on it, because it's going to make your practice so much easier in all areas if you're able to be on the same page with your client. We talked about clients who communicate too much and being honest with them, having that conversation. Again, that can be difficult, but they're going to appreciate, I think, not having to pay that bill at the end of the day when they're communicating with you 15 times a day and you've got to charge them for reading all that communication. Again, clients don't like surprises, so you want to have that conversation with them that, look, this is costing you money. I'm going to have to charge you for this. Stop. And I'm only responding to one thing a day. And again, clients who don't communicate enough, you've got that obligation to keep in touch with them, keep them updated, and always get instructions from them. Some clients want a sense of the timing as to within which the next step is taking place. Like, when are you going to write that letter to the other side? My tip on that would be, don't give specific dates. Just say you're going to get to it as soon as you can. If you do find yourself painted into a corner and you've got to give some time, make sure you pad that a little bit. No one's ever going to complain that you got something done early. But if you told them you'll have it done by Friday and it's not done by Friday, they're going to come to us saying, my lawyer's not attending to my matter. Fees, make sure you're communicating about those. Both in your retainer letter, setting out what the fee rate is, whether it's a block fee, whether it's hourly, how much the hourly rate is. But as things go on, you want to have that conversation with the client. And again, it can be difficult to talk to clients about fees, but when they get surprised by things is when they freak out and when they come to the Law Society. If you have that open communication about fees and there are no surprises, then they're probably going to stay away from us. And again, scope of work, retainer letters. If you can put out in the retainer letter what the scope of the duties you're going to do is, that'll go a very, very long way. Being organized. Easier said than done. People have a lot going on. It's hard to stay on top of everything. It's hard to stay organized, but it is the best way to avoid delay complaints, absolutely. If you know what's going on, you're much less likely to let things slip through the cracks. If you have a system where you're reviewing files that you haven't touched in 30 days, 60 days, and those are coming to your attention, you're able to deal with those as opposed to just letting them sit for 3 years. And then you get charged for something that was relatively simple to do right off the hop. And also being organized helps you say no. It helps you know that you've got too much going on right now. You're not able to take another client on. Again, that can be a very difficult conversation to have with somebody. Everybody wants to help out. Everybody wants to take it on. But there comes a point where you've got so much work, you just can't handle anything else and deal with it in a reasonably timely way. Being organized helps you know when you're at that point. So certainly make sure that you're organized. Apologize. More often than not, people don't want to come to the Law Society. They just want their matter dealt with and they want to move on with their lives. If something does fall through the cracks and you haven't been able to get to it in a timely way, say that. Apologize to them. Say you're going to get on it right as soon as you can and actually do that. Move their matter along. They're going to be happy that the thing's moving and they're not going to come to us. The situations arise where the lawyer gets defensive, says, you know what, I'm just too busy right now. I'll get to it someday. And then the client feels like they have no other option. They've got to come to us to get their matter moving along, because that's ultimately what they want, is to get their matter done, put it behind them and start living their life again. Part of the apologies can also take fees into account. Quality of service concerns that we get a lot of times are actually consumer disputes, right? Somebody says they're paying full price for service and my lawyer wasn't attentive to my matter. Why do I have to pay what I would if they'd given me perfect service? Saying that you're going to discount the fees and saying, I'm sorry, it didn't get done as quick as it maybe should have, will go a long way to preventing somebody from coming to us. If you have the opportunity to deal with those disputes yourself right off the hop, it'll save you a lot of headaches down the road. And then in the event that they do complain, that's also good to bring up to us in the course of the investigation that, yeah, maybe things didn't get done as quick as they should have, but I apologize to the clients. I offer them a fee reduction. That helps us say that you recognize the issue and you're trying to deal with it. Because at the end of the day, what we're here for is public protection, to try and prevent these issues from happening again. And if you're able to say that, I recognize the issue, this is where my system broke down, these are the changes I've made so it won't happen again, it helps us not take a more stern approach than we would otherwise if your response to that situation lets us think that you don't recognize the issue and you don't understand that what happened was not the way it should have happened. So if you have the chance to apologize and deal with it with the client right off the hop, that's going to go a long way to helping you, even if it does progress further down the road. Caveat to that would be negligence issues. There is the obligation under 7.8 of the code. When you have been negligent and your conduct has caused damage to the client, you don't want to admit liability, right? So you want to tell them the facts of what happened without admitting liability, tell them to get independent legal advice, because now potentially you're in a conflict. You have your own skin in the game and that you've made an error and caused them damage. So they need to get another lawyer. When that happens, make sure you're reading 7.8 of the code and dealing with it that way. Just follow up or finish up here with a couple of tips about handling complaints. Don't freak out. Getting a complaint doesn't mean that you're a bad lawyer. It doesn't mean that you're a bad person. The stuff does happen, right? A lot of times you're gonna have a reasonable explanation for it. And if you don't, then you don't. You'll deal with that when it comes, but don't freak out. We're not here to disbar everybody we can disbar. Take a deep breath and deal with it. If you want to have a call with myself about the process because it's your first time going through this, feel free to reach out. I don't know right off the bat who has a complaints history and who doesn't. That's not something that's disclosed to me. In Manitoba, it is. So I know when a complaint comes in, what somebody's history is, and if they haven't had a lot of complaints or they haven't had one in a while, I'll reach out by phone right away before they get any kind of letter saying, this has been filed. If you have any questions, now's the time to ask them. If you want to review the stuff and then give me a shout, here's my number. But basically, don't be afraid. Also, don't sue. We have seen that, and there is case law in Ontario and Alberta that suing somebody for filing a complaint is professional misconduct in and of itself. So we've had a situation where somebody sued or somebody filed a complaint. Found to be not warranting further conduct, and then the lawyer sues for defamation. That creates a chill on the regulatory system in the eyes of the judiciary who have looked at that issue before. You need to respect that somebody has the right to file a complaint if they want to, and you need to respect the fact that the process is going to work out the way the process works out. That's just the way self-regulation goes. Don't freak out to the point where you're suing.
I have a question from a senior member in the chat asking, if we get disbarred, do we get some time off?
That's up to you. If you want to find a new job right away, fill your boots. If you want a vacation, that's all you.
I think you might want to retire.
Best way to go about it, but.
No. Be honest and acknowledge when there is something wrong, right? We talked about that before. If there is an issue, recognize it. Take a step back, take a look at it. If you can recognize it and deal with it yourself right away, which is the next point, that goes a long way toward helping us say that it's something that doesn't need a more serious response from the Law Society. People make mistakes. Nobody expects you to be perfect. You're not going to be judged for having, let something slip through the cracks. It looks so much better on you if you can recognize that and address it yourself than having the Law Society come to you and say, well, really, something was wrong here. We need to do X, Y, and Z to fix it going forward.
And interject. When I started in this role, we had an online complaint submission available through our website, and it was wild. What was happening, like the number of complaints and vexatious complaints that came in, and I, rallied to get that taken down. The number of calls that come to me prior to somebody filing a complaint, honestly, it's a lot. And I want to be able to speak to people before they file a complaint, because honestly, 99% of the time, they just want their lawyer to call them back, or they just want they want a course of action. So I always give them that option. I said, I can call the lawyer on your behalf. I speak to them. I say, hey, if you want to avoid a complaint, this person's calling me. Every single time it has worked, honestly, in like almost every single scenario. So just know that we're trying to keep complaints that don't warrant any hearing, or you know what I mean? We don't want people to get disbarred. We don't want to have to go through that investigation process. We're trying.
And we have a similar process in Manitoba too, where we call it early intervention, where somebody can call without having to file a written complaint and say, I've been trying to get in touch with my lawyer. They're not getting back to me. Can you please give them a call? And we'll do that, and it's effective. Nobody wants to deal with the Law Society. Complainants don't want to go through the intake process and fill out all the forms and do the complaints. Lawyers don't want to have to deal with that stuff. So if we're able to reach out to them and, get that matter moving forward, because at the end of the day, that's really all the person wants is to get their matter done and move on with their life. Paper your file. It goes a long way toward helping you know where the file is at first and foremost. That's the whole purpose of the file, to be able, for somebody else who's not familiar with it, to be able to pick it up and run with it if you get hit by a bus tomorrow. So make sure that communication is on the file, the instructions from the client, communications, all of that stuff. However you keep your files, whether it's electronic, whether it's paper, whatever, make sure you're keeping all that stuff in there. Especially notes from verbal conversations. So we'll see a lot of our complaints where the client says, the lawyer never told me this. Some lawyers will respond and say, yes, we did. We had this conversation 2 years ago. I don't really remember when, but I'm sure it happened. Other lawyers will say, yes, we did. We had this conversation 2 years ago. Here's my note from the conversation, or the memo I made afterwards, or the email I sent to the client confirming the conversation. That is a much better response than saying, yeah, I think we talked about it. So make sure you paper that file, make sure you have that on there. Out of office or autoresponders. If you're too busy to deal with things because you've got a trial, because you're in the middle of a big closing, something like that, there's some big file that's taking up a huge chunk of your time and it's going to put you behind in communications. Put an autoresponder on your emails, put it on your voicemail saying that, I appreciate you reaching out. I'm not going to be able to get back to you for a few days, but I will at my earliest opportunity. When you're doing something like that, also put that on the file. So that, 3 years from now, when somebody's complaining that you weren't getting back to them, and you don't recall what was happening on that date 3 years ago, you're able to go back to the file and say, oh yeah, I was dealing with this big closing. I told the client I wouldn't be able to get back to them right away, but then ultimately I did. Make sure that's on there. It's really going to help you out when you do have to respond to something. And then provide those documents. I don't know why this happens, but some people just give a response and don't provide supporting documents. Even though they've papered their file really well, they'll just, shoot off their response and not support what they're saying. If you have support, give it. I mean, you want to put the best case forward possible right off the top so that we don't have to go back to you and ask further follow-up questions. It'll take much less of your time to deal with a complaint if you give a full and complete response with any backup documents you might have right in your first initial letter. Hopefully that's the only time you ever have to respond, is that one initial letter, if you provide all that information in there. I'll just finish up with act with integrity. Obviously, that's the foundation of the legal profession, right? That is our number one core principle, is that you act with integrity. That applies both in your practice and in the complaints process. Some people will try to, I don't want to say mislead, but they'll play with the facts a little bit. Don't do that. Again, be honest, acknowledge if there's an issue. And definitely don't lie.
Don't avoid.
Yes. So we had a matter, I'll just finish up with this story, where a lawyer was doing work for a client and was billing and was getting paid, but was also taking additional payments that they weren't billing for and weren't running through trust. In an attempt to avoid taxes. So they were doing that. We got wind of it, went to the lawyer. The lawyer said, I would never do that. This is my practice. These are all the bills I issued. These are my trust records showing all this money going through trust. And then the client comes with cell phone recordings that they had made of their conversation with the lawyer about being paid under the table, about avoiding taxes. So obviously things were bad from the beginning, but they became so much worse afterward. So,
I wasn't here.
no, no, act with integrity. Any questions at all about anything?
Just have a quick question. How long does your process usually take for an investigation? I know it varies depending on what.
Yeah,
So I
it
would say like
varies.
a fairly standard, you just need one response from the client, one response from the lawyer.
We would try and wrap it up within 90 days. That's the goal. Doesn't always work out that way. But that is the goal.
A lot faster now.
Yeah, is that overestimated? Cause you said to give some buffer.
It can be. Hopefully it is, yeah.
I mean, I think
If things were that easy, then absolutely. If it was one response back and forth, then perfect. We could wrap that up in 90 days. Doesn't always work out like that, but
I have someone in the chat saying, when you receive a complaint, contact another lawyer who is a friend and get someone to agree to hold you accountable for giving a full timely response. Avoid getting an additional charge for failing to respond to a complaint. Otherwise, it's easy to get paralyzed and not respond.
fantastic advice.
I'd
Fantastic.
say the not responding is definitely something that comes up often. It's just avoiding. Do it.
Yeah. Again, don't freak out, right? Be able to take that breath.
That comment that you just made makes more sense to me than don't freak out, because you absolutely will freak out.
It's
So
okay,
freak
just don't
out
avoid.
first,
Yeah.
Then do that thing.
Just like,
Take a breath,
It's
talk to
inevitable
somebody
that
if you
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 need
can
to.
freak out on the inside.
Yeah.
But don't hide because it looks suspicious.
Yeah.
And it's, it's more work for us. And then it's Chris saying like, listen, this person's not calling me back. What do I want to say? Oh, I'll call them. I'll email them. You know what I mean? Just respond, just respond.
Yeah. Okay, so if you have any questions, always feel free to reach out. Happy to talk. That's my phone number. I've got those 2 email addresses there, so feel free to reach out. Any questions you might have about complaints process, feel free.
Are you sending these materials or should I take a picture of that screen?
You can take a picture. Yeah, I don't know if,
I would
Jessica.
love to have them and I could give them to everybody that registered.
Thank you.
yeah. Okay, perfect. Thank you all.
Thanks,
Thank
Chris.
you.